Hi, I'm Sara Ramshaw, and I'm a law professor at the University of Victoria in British Columbia, Canada. My research interests fall broadly into the area of arts-based approaches to law, with a specific focus on the improvisatory arts, especially music, dance, and theatre. And I have over 15 years' experience teaching family law to students in the common law jurisdictions of Northern Ireland, England, and now Canada. Before I begin, I must emphasize that the research I am sharing with you today is extremely preliminary in nature. While these thoughts have been recently written up and are slated for publication in the Routledge Handbook of International Law and the Humanities, edited by Shane Chalmers and Sandhya Pahuja later in 2020, much more research, including empirical research in the form of interviews with key stakeholders, is required. And I have recently been awarded 2 research grants, including one by the Canadian Foundation for Legal Research, which will be utilized to undertake this. Perhaps more importantly, I'm making this video during the global coronavirus pandemic, in which law courts have been closed and much family law dispute resolution has moved online, not only in British Columbia, but in other parts of Canada and globally as well. I have not yet had the opportunity to carefully consider the influence of COVID-19 on my research into machine listening and digital family justice. However, this will be a priority for me in the coming months. Also, although I try and avoid as much as possible making pronouncements about how life has now irrevocably changed, I do think that there will be a pandemic consciousness in family law dispute resolution moving forward, and thus is something that anyone teaching, researching, or practicing in this area will have to be attentive. The Rainbow Family Law Project, as I am tentatively calling it, follows on from previous interdisciplinary research I have undertaken with musicians and sound artists, as well as legal and social work professionals, which found that family justice requires an improvisational approach to dispute resolution. Such an approach invites responsiveness, adaptability, and creativity by judges and lawyers when they apply general rules to specific legal matters. For more information on this past research, see the Translating Improvisation website. What we found from this research is that litigants are more likely to accept a legal decision, even one that goes against them, if they feel they have actually been listened to by the judge and had their case properly considered. As one of the Northern Irish judges we work closely with on our project stated, if people genuinely feel that they've been listened to, that the judge has understood their point, that the judge has given them proper consideration, even if they lose, they can deal with it, because they have been listened to. And it is a key task for any judge to not just listen, but to convey the fact to the person that they have been listened to. More recently, my interest in attentive listening and creative legal decision-making quite unexpectedly morphed into an interest in machine listening, improvisation, and justice. This move owes much to the involvement of one of my key collaborators, improvising musician Paul Stapleton, with the interdisciplinary research network Humanizing Algorithmic Listening, or HAL, which explores the active role that technologies play in mediating our relationship with the world. For more information, see the website address at the bottom of this screen. About 2 or 3 years ago, I also started collaborating with legal academic James Parker, based at Melbourne Law School, and met his collaborator, curator, researcher, and sound artist Joel Stern, who is also the co-artistic director of Liquid Architecture. Their work on acoustic justice and machine listening has significantly influenced the direction of my research. The Rainbow Family Law Project will examine the potential of technologically mediated listening by critically assessing the role of artificial intelligence in relation to digital family justice. Whether we agree with it or not, family law dispute resolution is becoming increasingly digitized in contemporary society. Thus, it is timely and necessary to undertake a careful investigation of the current and potential use of digital family law and to develop a critical framework for examining the role that listening algorithms may play in resolving family disputes, to ensure that what is dispensed by machine judges approximates something like justice. One of the key research questions in this project is, can machines ever listen deeply and attentively to the singularity of a family law case, such that they are able to offer the creative and bespoke solutions that family justice demands? When I first started thinking about digital family justice, I wanted to find out what sort of information is readily available to the average family law litigant via machine listening technology. So I asked my iPhone Siri the following: "Hey Siri, I'm getting a divorce. What should I do?" The most common response I got from Siri was,
"I'm sorry to hear that."
On occasion, Siri provided an equally non-committal or evasive answer.
"That's too bad, but I'll always be here for you."
Before I go any further, I would just like to stress that I am in no way unmindful of the serious legal and ethical issues associated with machine listening, and I am extremely attentive to the dark side of machine listening, or voice assistants such as Siri. However, this research is responding to two trends in contemporary society, both pre- and post-COVID. The first is the increasing digitization of family law dispute resolution in the form of online information provision, mediation, and even adjudication in some jurisdictions. The second is the widely accepted view, held almost universally, that increased digitization, not only in family law, but in other areas of law as well, leads to an increase in or heightened access to justice. This quote by David Hodson is very much indicative of these trends. He says, "Governments around the world know that digital technology is probably their only savior in coping with the massive demands of family justice." In terms of what online dispute resolution or ODR technology already exists, the current global leader is British Columbia's Civil Resolution Tribunal, or the CRT, which is the first court-designed and publicly financed ODR system in the world, and is a mandatory path for certain defined categories of disputes, such as motor vehicle injury, small claims, and strata or condominium property disputes. The CRT, and technology more generally, is said to align with access to justice objectives, in that it removes barriers like cost, time, and information asymmetry by providing free legal information and tools via the internet, enabling litigants to, as you can see on the screen, resolve their disputes online 24/7, thereby saving time, money, and stress, with the end result being accessible, timely, and fair resolutions. At present, British Columbia's CRT does not hear family law cases. Yet, with separation and divorce being one of the most significant personal and legal challenges faced by people, the question then becomes, is it not a worthwhile endeavor to try and innovate the legal process of divorce or separation, reducing its adversarial nature and making it more understandable and easy to follow? With this in mind, in August 2019, BC's Legal Services Society, or LSS, launched a free online mediation platform called MyLawBC Family Resolution Center to help couples negotiate parenting time, vacations, and other important details regarding their children's care upon divorce or separation. It is the first service of its kind in Canada and perhaps the world, and aims to enable low-income parents who would not be eligible for referral to a legal aid lawyer to create a parenting plan together online, which can then be finalized into a consent order or a binding legal agreement. If the couple is unable to agree on certain topics, they can access up to 5 hours of free online assistance with a professional mediator qualified under the BC Family Law Act to assist with this task. I have not yet had a chance to gather statistics or interview those involved in this ODR system to assess its success. However, this will be one of the first tasks I undertake with my Canadian Foundation for Legal Research funding. In relation to the use of ODR, it is important to note that many argue family law is not easily adaptable to online dispute resolution due to its necessarily flexible and highly discretionary nature, and especially where children are involved, there are often nuanced issues to consider alongside the need to take account of their best interests. Thus, digital systemization becomes far more difficult and problematic in the area of family law than perhaps in other areas such as strata and small claims disputes. That said, legal professionals and academics such as David Hodson are very keen to digitize family law, encouraging more settlements and more use of formulaic-based approaches. In the words of Hodson, the law must be adapted to digital processes. For Hodson, though, this legal adaptation must, as the quote on the screen explains, not be so sophisticated and keen to produce a tailor-made outcome for every individual case, as to make it so expensive, so complex, and so hard to predict, as to put off both lay parties and digital programmers. Of course, IT is the servant of the law, but the law must adapt to work best with IT. This is not a challenge to fairness. It is a challenge to produce an accessible justice system. My previous research in Northern Ireland has found, though, that justice in the family law realm is not just about accessibility or saving time, money, and stress. Family justice requires deep and attentive listening to the singularity and unique circumstances of a family conflict, and finding creative solutions to these disputes. Once again, quoting the wise words of Judge Smith, "Every child is an individual. Every family problem is individual and needs a bespoke solution." Creativity and attentive listening are thus essential features of family justice. In support of this argument, Part 3 outlines the use of algorithmic or machine listening in the fields of improvised music and the sonic arts, and queries whether advancements in these areas might be transposed into the legal realm to assist with the attainment of digital family justice. As mentioned at the beginning of this talk, I have written extensively about the improvisational nature of justice as a negotiation between the singularity of a particular case and the pre-existing rules or laws to which it must adhere or follow. As a social practice that is learned and culturally embedded, improvisation is crucial to any discussion of digital family justice. Focusing on a key feature of improvised activity, namely deep and attentive listening, I will now turn to two key questions. The first is, can machines improvise? And secondly, if so, why do we want them to? As a pioneer in and staunch supporter of what he calls creative machine listening, I will look to the work of improvising trombonist, composer, and computer installation artist George Lewis to guide this discussion. The idea of machines improvising may sound strange, nonsensical even. Is not machine behavior the exact opposite of improvisation? Predictable, programmable, systemized, and generalized? And yet it is important to note that musical improvisation by human actors, although often defined or categorized as providing substantial fresh input to a work in the time of the performance, for the most part must be based on pre-existent materials, structures, and rules. Thus, while conventional wisdom holds that musical improvisers simply make it up as they go along, or just let sounds be themselves, as George Lewis reminds us, creating within the conditions of the moment requires immense discipline and skill, and must be based on one's history, culture, and practices. That said, the simple application of rules will not guarantee a successful improvisation, be it in a human or an automated player. Thus, improvisation in both humans and machines requires simultaneous structure and a certain degree of autonomy, such that one is able to not only implement the rules of improvisation, but also facilitate non-deterministic, surprising, perhaps even creative and aesthetic decision-making. Looking to the fields of aesthetics and computational creativity, there is evidence that machines can produce artistic outputs. For example, Rainbow Family was the first of George Lewis's interactive virtual orchestra pieces. It featured up to 4 human musical improvisers performing with a network of 4 computers. 3 of the machines represented autonomous performers connected to synthesizers producing sounds. A central computer functioned as an ear, analyzing the individual offerings of the computers and the collective performance of the human-computer musical interaction. Celebrated as a groundbreaking work, Rainbow Family employs proto-machine-listening software to analyze an improviser's performance in real time, while simultaneously generating both complex responses to the musician's playing and independent behavior arising from the program's internal processes. Drawing upon artificial intelligence and practices of free improvisation, Rainbow Family includes machine subjectivities as central actors. The creative machine, in other words, is not only able to analyze a fellow human improviser's performance in real time and respond to it, but also provide its own musical contribution in accordance with the program's internal processes. Lewis designed these creative machines to perform in a manner that utilizes key elements of improvisation, both within and outside music, such as staking out territory, assessing and responding to conditions, and asserting identities and positions. So machines can, as Lewis and others have demonstrated, be creative improvisers. Why, though, do we want machines to improvise? The question of the possibility of improvisation in machines is very much tied to this question. What, in other words, do humans gain by creating improvising machines? Or what does technology offer improvising musicians which would tempt them to interact with computers? To answer this, it is worth mentioning that even the most skilled improvisers experience certain constraints on their ability to process information with the speed required for virtuoso improvisation. Accordingly, one response as to why we want our machines to improvise is that by teaching machines to improvise and/or exploring creative machine improvisation, we not only learn something about AI and technology, but we also learn something about the processes of improvisation in humans and about ourselves and our environment. For George Lewis, questions about the possibility of improvisation in machines encompass not only technological or music theoretical interests, but philosophical, political, cultural, and social concerns as well. While there is anxiety felt by improvising musicians, just as there is by lawyers and judges, that humans will be replaced by machines or robots, Lewis believes wholeheartedly in the benefits that humans acquire by studying and honing cyborg sociality, particularly as it relates to the skills of interactivity and attentive listening. The techno-human creative process is very much dependent on listening, which is by its very nature an improvisational act, one that is engaged in by everyone. According to Lewis, working with creative machines offers a means of creating a politically inflected, critically imbued aesthetic space, and machine listening as improvisation announces a practice of active engagement with the world where we sift, interpret, store, and forget in parallel with action and fundamentally articulated with it. In the final section, I will offer some very preliminary thoughts about the potential benefits and pitfalls of introducing machine listening into the family law realm. In his 2018 article, Machine Listening as Improvisation, Lewis offers Rainbow Family as a provocation concerning the act of listening. He explains, the ontologies of creative machines and the hybrid ontologies of encounters between them and human musical improvisers, or even with other machines like themselves, depend upon a fundamental construction of something that we are pleased to call listening, in which the exchange of sonic features leads to a form of sociality. When I first began to investigate the increased digitization of family law, instinct told me that my previous research on justice as improvisation would be of limited value. Is not improvisation naturally the preserve of human actors? Something all humans do every day? Yet after delving more deeply into the subject of improvising automata, particularly the interactive, computer-driven systems created by George Lewis, such as Rainbow Family, I found myself perhaps not yet a convert, but definitely more open to the possibility and potential of digital family justice. In particular, I am intrigued with the concept of machine listening as a listening with, that is, as a listening alongside machines in a manner such that our skills as human listeners might be enhanced. Creative machines listen not so much for what is happening now, but for what is likely to happen next. This is perhaps why listening has been described by some as fundamental to human evolution. The question with which I would like to leave you is how might technology and machine listening enhance human skill and understanding in relation to family justice? It has been said that trust is key for people going through divorce, and litigants must feel like they are being listened to by those dispensing legal advice or making decisions in relation to their disputes. Thus, any ODR system focused on family law issues must make attentive listening and social interactivity or relationality with the participants a priority. As evidenced by Lewis's interactive computer-driven systems, it is possible to program machines such that they produce outputs that not only embody meaning, but also announce emotional and mental intention, and perhaps most importantly for digital family justice, mirror the emotional states of those to whom they are listening. A great deal more can be said about this topic, and the question of whether it is desirable or even possible to create an interactive computer-driven system aimed at assisting family law litigants with ODR processes remains open for debate. Ultimately, though, paraphrasing Lewis, the subject in question here is not technology or artificial intelligence, but justice itself. How we respond to the call for increased digitization in the name of family justice says as much about us as a legal community as it does the machines themselves.